Welcome back to our channel. I'm Chelsea Kennedy, the Executive Practice Coordinator here at Butler Wills & Estates. For this week's video, we wanted to answer a question that we get asked almost every day. What is the difference between probate and administration, and which one do I need? We're going to take a look at what the difference is between probate and administration, what that means for applying for either one, and what the application process is like. We'll also cover how to tell which application you need. The first question we need to ask is, why would you need probate or administration? Why would you need probate or administration? Either one of these applications is used after someone has passed away, and there needs to be a person in charge of the estate. Probate is used when there is a named executor, and administration is used when there is not. Not all estates require probate. Whether or not probate is needed depends on the type of assets in the estate, how those assets are owned, and the value of those assets. In some cases, these factors also apply to administration. For example, let's say there is a property in Newfoundland owned jointly between a legally married couple, and one person in the couple passes away. Probate or administration would not be needed in this situation because there is a surviving joint owner. The surviving owner has the right to retain the property regardless of whether or not the estate is probated. On the surface, the difference between probate and administration is based on whether or not there is a valid will. To apply for probate, there needs to be a valid will. We'll take a look at what makes a will valid in a moment. For administration, either there is no will or there is a will that isn't valid. Also, when there is a will putting someone in charge, that person can get started managing the estate as soon as the testator passes away. The executor may not be able to do everything right off the bat, but there are certainly some aspects of handling an estate that the executor can get going on. When there is no will, there isn't anybody who has the legal authority to do anything with the estate. This means everything needs to sit and wait until someone is appointed as the administrator. The basic difference makes it pretty easy to determine whether you need probate or administration. Of course, as with all legal concepts, there's more to the issue than the basic difference. Let's take a closer look at the difference between probate and administration. For a probate application, there needs to be a valid will. In some provinces, this can be either a typed will or a holographic will. A holographic will is one in which the will is written by hand. Keep in mind that holographic wills are not valid in all provinces. For example, currently holographic wills are valid in Newfoundland and Labrador, but they are not valid in British Columbia. The will needs to appoint an executor, and it must be witnessed and executed properly. For the will to be executed properly, a few signing requirements must be met. First, typed wills must be signed in front of two witnesses. These witnesses cannot be beneficiaries named in the will, nor can they be the spouse of a named beneficiary. The witnesses must also be over the age of majority for the province where the will was made. These signing requirements apply to wills that are completely typed and also to wills made from kits that use a fill-in-the-blank approach. Holographic wills, on the other hand, do not need witnesses. They must, however, be written 100% in the person's own handwriting. In many cases, people think they can sign a will that is written in someone else's writing, and it will be valid because the will is handwritten. This is not the case. If a will is in someone else's writing, it is treated the same as if it were a typed document. This mistake is frequently made with will kits. Oftentimes people think handwriting in their name and the details makes the document a handwritten will, but it doesn't. Also, remember that since holographic wills are not recognized in all provinces, a holographic will that meets these requirements may still be deemed invalid in jurisdictions that do not accept handwritten wills. There are a few different types of administration, and this is where the basic difference between probate and administration becomes insufficient. The type of administration that is required depends on whether there is no will, an invalid will, or a previously appointed administrator. Let's take a look at each type of administration in more detail. In each type of administration, someone needs to be appointed by the court as the person in charge of managing the estate, because there is no appointed executor. The most straightforward type of administration is used when there is no will at all. In this case, the person who passed away did not have a will, either typed or holographic. The next two types of administration include Latin in the name. The Latin names are not used in all provinces, but the type of administration still exists. Administration CTA, or cum testamento annexo, means administration with will annexed. In this situation, there is a will, but it does not appoint an executor. Many homemade wills fall into this category because people give away their items but do not put someone in charge. Administration DBN, or de bonus non, literally translates to mean incomplete goods. This refers to a situation where there was an estate administrator appointed, but he or she became incapacitated or passed away before the estate could be completed. Now that we know what the different types of applications are, let's look at who can apply for each one. One of the first steps in a probate or administration application is deciding who will complete the application. For probate, the will states who the executor is, and the executor is the only person who can apply. If the named executor is unable to apply because they are deceased, incapacitated, or otherwise unable to accept the job, then a named alternate executor can complete the probate application. In the event that the first named executor is alive and capable of taking on the role, but chooses not to, he or she must formally renounce their right to the job in writing. This renunciation will be filed as part of the application. If the first named executor wants to renounce, he or she must do so before any work on the estate has been done. When it comes to administration, determining who can apply is a bit more complicated. There is a hierarchy of who has the greatest right to apply. If someone higher in the hierarchy decides not to take on the job, they must formally renounce in order for someone from the next level in the hierarchy to apply. The most straightforward situation is when there is no will at all. In this case, the laws of intestacy apply, and the person who is the next of kin has the first right to apply, and the list continues through the person's relations. If the deceased person was married, the person with the greatest right to apply is their spouse. If there is no spouse, the person's children can apply. Since all the children have the same right to apply, if some of them do not want to take on the job, they must renounce so that a sibling can apply. The same hierarchy applies when there was a previous administrator but no will. In this situation, who the administrator would be was already determined, but the person was not able to complete the job. The next administrator would be from the hierarchy of next of kin. When there is a will but no executor is named, the people who can apply are the beneficiaries listed in the will. This is because these individuals have a vested interest in what happens in the estate. In cases where there was a previous administrator of a will with no executor, the beneficiaries named in the will will have the greatest right to apply to manage the estate. The application process for probate and administration are very similar. In both applications, there is a package of documents that is filed at the court. In the vast majority of cases, probate and administration applications are done completely on paper, and no one needs to appear in court to speak to a judge. The first step in both processes is determining which kind of application is needed. This will determine which additional forms are needed for the application. Once the type of application is determined, the applicant gathers information about the estate, including assets, liabilities, and other financial data. This information is needed for the application. It is easier for a named executor to get information about the estate than it is for an administrator, because the executor has a will that states that they have a right to the information. All of this information is put into the documents, which are then signed with a commissioner for oaths or notary public. The completed documents are then filed at the probate office of the court, along with an application fee. This fee varies from one province to the next and is based on the value of the estate. A judge reviews the application, and if it is correct, the judge signs an order granting the probate or administration. As we mentioned, there are additional documents that may be needed, depending on the type of application. For probate applications, the original will is required, along with a document called a proof of will. The attached image is an example of a proof of will for a holographic will in Newfoundland. The formatting is different across the country, but the basis of the document is to have someone who is familiar with the deceased person's handwriting to state that they have seen the will, and the writing is, in fact, that of the deceased person. The proof of will for typed wills is similar. For a typed will, the proof of will is signed by one of the witnesses to the will and states that the person saw the testator sign the document and that the testator had his or her capacity at the time of signing. Each of these types of proof of will is sworn, so so the signer must execute the document in front of a commissioner for oaths or notary public and swear or affirm the document to be true. The additional documents needed for administration are a bit different than those needed for probate. In many jurisdictions, the court will require that the applicant obtain an administration bond. This provides the court with the assurance that if the applicant takes the assets in the estate and does not pay the just debts, that there will be some way of recovering the value of the estate. There are two ways to obtain an administration bond. First, a bond can be purchased through an insurance company. This requires that the applicant pay a certain amount upfront based on the value of the estate and the insurance company's rates. Some companies will charge a few years' premiums upfront and refund the additional years if the bond is no longer needed. Alternatively, the applicant can have an estate lawyer draft an administration bond with two sureties. The example here is the beginning of a bond for Newfoundland and Labrador. In this document, two people swear to pay the debts of the estate up to a maximum of the total value of the estate if the administrator neglects his or her duty. This option does not require any upfront payments, but it does mean that the applicant must find two adults who reside in the jurisdiction of the court who are willing to be responsible for the debts of the estate should it be needed. The result of either application is a court order. This order names the applicant as the person in charge of the estate. The court order also gives the applicant the legal authority to manage the estate, including transferring assets and paying estate debts. Not only is this person now allowed to receive someone else's money or sell someone else's house, but the institutions they're dealing with are indemnified of any risk. The institutions, such as the bank, are following the court order when they hand over the deceased person's bank account to an executor or administrator. In addition, the applicant is now someone who can be held accountable for everything that happens in the estate. The executor or administrator is responsible for managing the estate and is liable for any losses. We've published a do-it-yourself kit for clients who want to complete the application for probate or administration on their own. Currently, these kits are available for Alberta and Newfoundland and Labrador. Each kit is available on our website or in our office. The Alberta kit can also be purchased from Self Counsel Press. The kits contain detailed instructions for what to include on each line, completed examples, and blank forms you can use for your application. Every kit has paper copies of the forms, as well as electronic copies. The forms for the applications for every province are available for free through the website for each province or through the Queen's printer. However, these forms do not come with instructions for filling them in. One of the options for completing an application for probate or administration is to have a lawyer do the application for you. The fee will vary from one lawyer to the next and may be based on the value of the estate. We use a flat fee that includes all emails, phone calls, printed pages, etc. You can also sign up for our e-newsletter. Get information straight to your inbox once a month, including articles, upcoming seminars, coupon codes, tips, and more. Don't forget to check out our website. We have a selection of free resources available to the public, and you can find all of our books and ebooks. Where to find us? Visit our website at butlerwillsandestates.com or send me an email directly to chelsea@butlerwillsandestates.com or give us a shout at 709-221-5511. If you like this video, make sure you click that like button, and if you want to see more videos about estate law topics, make sure to click that subscribe button. If you're already subscribed, be sure to click the bell icon so that you get a notification every time we post a new video. Stay tuned for our next video series about the different supporting documents that go with a release, and thanks for watching. Where to find us? Check out our website, butlerwillsandestates.com, or send me an email directly at chelsea@butlerwillsandestates.com, or call us at 709-221-5511. If you liked this video, make sure to click the like button, and if you want to see more videos about a variety of estate law topics, make sure you click the subscribe button. Thanks for watching, and we'll see you at our next video.